My chance new girl watch made in China. We play ping pong ball made in China.
Hello and welcome to China Econ Talk. I'm Jordan Schneider, your host, here today with Professor Henry Cao, who is the Associate Professor of Law at Singapore Management University and also the Dongfang Scholar Chair Professor at the Shanghai Institute of Foreign Trade. He is the co-author alongside Gregory Schaffer of the recent paper, China's Rise, How It Took on the U.S. at the WTO. So as evidenced by China's recent behavior in the trade scuffles with the U.S. going on nowadays, it's clear that Chinese lawyers are far from rubes when it comes to trade. So in this interview, we'll discuss what it took for the PRC to learn to speak the language of international trade law and the implications of that knowledge both domestically and internationally. Henry, thanks so much for coming on the show today. Great to have you here.
You're welcome, Jordan. It's my pleasure.
So my first question for you is a personal one. What first got you interested in studying trade and trade law?
Well, that was I think about 17 years ago when I was a young student at Vanderbilt University doing my JD degree. I was then the president of the Student International Law Society. And one of my tasks is to invite speakers to the law school. So once I had the pleasure of inviting James Backus, who was the chairman of the WTO appellate body and also the first American to be on the appellate body. It's a bit like the Supreme Court for the WTO. So he came over and he gave a talk. The talk apparently is about the WTO international trade law and so on. So after the talk, I had a chat with him, and he mentioned that the WTO has this internship program, and one can only apply to this program if you are a citizen of a member country. So it was a lucky moment for me because China just joined the WTO. Then I was a Chinese citizen, so I was eligible to apply. So I applied to the program, and I got in the program as an intern in the appellate body secretariat, and that is basically how I started to get involved in WTO issues.
So what was that first experience like for you? Clearly you must have been a person of some interest to the WTO. Other staffers, as you're one of the first Chinese folks to show up. It must have been, yes. Yes,
I think it was an interesting experience both for me and probably for my colleagues as well, because I was when I arrived, there was only another Chinese at the secretariat, and he's not a lawyer. He's an economist, and he used to work for the UNCTAD, the United Nations Conference on Trade and Development. So I was basically the first lawyer to arrive in the WTO, and a month after I arrived, there was another lawyer arrived from China in the Legal Affairs Division. But for a long time, there was just two of us Chinese lawyers in the whole secretariat. So it was a really interesting experience. I mean, I learned a lot about how the WTO functions as an insider. And also I was able to kind of communicate in a way how the Chinese review international law, review especially WTO law to my colleagues. And I think that was a great experience.
So following that internship, you didn't go straight into academia, is that correct?
Well, I did the internship in 3 months. So the internship, according to WTO regulations, can last at most 3 months. So I finished in 3 months. And I was really lucky because I was able to complete a whole case from the beginning to the end in these 3 months, because a case typically takes 3 months in the secretariat, in the appellate body. So the case I was working on was the U.S. Bird Amendment case. That was a big case. After the 3 months, I was transferred to the Trading Service Division, which deal with service issues. And while in the Service Division, I was also lucky that I got involved in another case. That was the Mexico Telecom case. So I worked on that case for like 8 months, and also basically from the beginning to the end. And after that, I decided that, even though Geneva was a very nice city, but if I stay there and continue working on these cases, I basically can save my life, from that moment. So I decided to change my career to do something that has probably a bit more freedom. That is why I decided to join academia. I started in Hong Kong. So my first job was in Hong Kong, first with the City of Hong Kong for 1 year, and then I moved to University of Hong Kong for 3 years, and after that I came to Singapore. So I'm now in Singapore for 10 years.
So one of the interesting parts about this this whole arc is the level of student interest, which I'm sure you've had a front row seat in over the years. You speak in your paper about a WTO craze. So could you talk a little bit about the initial excitement that a lot of Chinese policymakers and law students as well must have had during that first early phase in 2001 when China was joining the organization?
Yeah, I think for the WTO craze, you really have to understand it in the context of the insular system for economic reform in the 80s and the 90s. I mean, that is, in my understanding, basically a continuation of the insular system for economic reform from the 80s and 90s. Because people at that time, the Chinese people and the Chinese government too, at that time, they really looked up upon the West, especially the U.S., as kind of the model for economic reform. And if you look at a lot of the reform measures during that time, it was basically in a way, following the approach that is taken in the West, especially the U.S. So people thought that joining the WTO, could enable China to emulate more of the U.S., and that is really why there was such a craze about the WTO. So as we discussed in our paper, there were a lot of support for the WTO in the States, from the top of the government all the way to the President Jiang Zemin at that time. Actually, President Jiang Zemin has organized this workshop for the governors level. So all the governors in China, he assembled them together in Beijing, and then they invited experts to give them talks on the basic principles of the WTO, on the rules of market economy, and so on. And President Yang himself also served as lecturer in one of those sessions. So that was top level. And then down to the street level, you see that all the people in China, no matter whether you are a scholar or student or even a taxi driver, they are all very happy about China joining the WTO. Actually, I think we also mentioned this in our paper. At the time of China's WTO accession, they even had competitions for taxi drivers, on WTO principles. And there was also a national show on WTO knowledge, and the guy who won the show, who was number one nationwide, he was flown to Geneva to meet with the Director General of the WTO. So it was all like very exciting in China. People are really excited about the WTO, and I think that is what we would call the WTO craze.
So what's interesting, though, is that even with all the popular and the popular enthusiasm and the enthusiasm at the government and professional level, there were still a lot of core competencies that the Chinese government and the Chinese government's lawyers didn't have, that they needed to get under their belt in order to make the most of the membership. So could you talk about what were the big barriers at first when it came to navigating the WTO process?
Yeah, well, there was a lot of enthusiasm, as I said, about joining the WTO, but people back then didn't really know a lot about the WTO. that is understandable because China didn't join the predecessor of the WTO, the GATT, for a long time. I mean, China was a founding member when the GATT was established in 1947, but then Taiwan pulled out for historical reasons. So China was basically shut out of the GATT for like 40 plus years. And nobody really knew, the basic principles of the WTO. So I think that is one barrier. That is the lack of familiarity with the technical knowledge in the WTO. So people didn't understand, for example, what is most favored nation treatment, what is the national treatment, and what is non-discrimination, what is transparency. All of these are basic WTO principles. So that is one problem. Another problem, as we discuss in our paper, is this language barrier, because the WTO has three official languages: English, French, and Spanish. And Chinese, even though it's the official language of the United Nations, it's not an official language of the WTO. So most of the documents in the WTO are available in English only, and that apparently poses a barrier to the Chinese. And another problem is that China traditionally is a civil law country. There are two major legal systems in the world: civil law and common law. So China, along with the continental Europe countries, are mostly civil law countries. But the US, UK, Australia, Singapore, these are the common law countries. So in common law countries, they use a lot of case law, as we lawyers would call them. So in the WTO, even though strictly speaking, it's not a common law system because it's international legal system, but there's a strong influence of a common law because the WTO has adjudicated all these cases, and the decisions of the panel and the appellate body in these cases basically become layers of case law in the WTO. And this is also very difficult for the Chinese lawyers to understand. So all of these difficulties, I think, was the reason why there was all these barrier to Chinese government, Chinese lawyers at the beginning.
So what steps did the government take to help the lawyers get on their foot? How did this learning process begin, and what were some of the effective methods?
Well, there are many ways. First of all, as I said, as we mentioned in our paper, there are nationwide campaigns to learn about the WTO, and this include top-level officials, the president, the ministers, the governors, and this also includes scholars, WTO scholars in China, people who used to study public international law but now shifted to WTO law, and students, and also lawyers. Actually, the Chinese government realized this, so they said upon China's accession to the WTO that one of our first priorities to train a group of lawyers who understand not only law but also economics and also English. So that was the top priority. And Chinese government established all these WTO centers around the country. So there are main centers, for example, in Beijing, in Shanghai, and in Shenzhen. And one of the main tasks of these centers is to train people, mostly lawyers, but also government officials, and also businessmen on WTO rules, so as to help them to understand what are the WTO rules and how they can take advantage of that. Now, with regard to China's participation in WTO disputes, we also discuss that is the main part of our paper, how the working with foreign lawyers. Basically, in most cases that Chinese government get involved in, they would hire both a Chinese law firm and also a foreign law firm. So the Chinese lawyer would work along together with the foreign lawyer, and in the process they can learn from the foreign lawyers, learn how to write, for example, legal submissions, how to advocate in court in the WTO panel and appellate body, and how to defend China's position. So I think throughout this learning process, we can see that the Chinese lawyers were able to develop their capacity, their ability in this so-called joint venture. It's just like the Sino-foreign joint venture for other business activities, where they basically learn the foreign technology, the foreign know-how, and that is how the Chinese lawyers got started.
Yeah, I do really think that's a fascinating a parallel to make, comparing, the sort of OEM process, the way that China's learned how to make so much manufacturing and services to this legal knowledge. So one of the interesting quotes from your paper is how one lawyer said he loved how, quote, legal the WTO work felt. I'm curious what you think was going through his or her mind, when this person said this statement, and what they maybe were comparing their past legal work they had to do to.
Right. I'm really glad that you raised this point, because actually the quote in our article didn't, because of a space constraint, couldn't capture everything that the lawyer said. But the lawyer meant, when we interviewed him, what he really meant was that when he looked at all these case reports from the WTO, where the judges painstakingly took the parties' arguments and analyze them, and then explain why, for example, he agreed with one party but not the other party, or he disagreed with either party, and then went into very detailed analysis of not only the arguments but also the words used by the parties. So you see that there's a really refined analysis of the meaning of specific wordings. For example, in WTO agreements, where the judges in the WTO would refer to, for example, the dictionary, the shorter Oxford dictionary on English, and the other dictionaries, and discuss in detail what is a specific meaning for particular words. And that is an eye-opener for that lawyer, because, even though he also practiced before Chinese courts, before that, but the way that the Chinese courts render its judgments is very different. I think this has to do with the difference between the common law and the civil law system too. Basically, in civil law countries, you see that the judges just cite to specific provisions in the law, in the legislation, and then say because of article so and so of this so and so law, therefore we rule for the defendant or the plaintiff, and so on. So there was not really a lot of analysis, a lot of discussion. And what really struck this lawyer is the level of sophistication of detail in the analysis, in the judgments from the WTO. And he really loved it, because this showed you how the judges were thinking about this issue, how they went about analyzing the issue. And this really helped you to understand the meaning of the agreements. And I think that is what he meant by how legal the WTO work was.
So this experience that this lawyer had of coming to respect more and more the decisions and the impartiality of the WTO is something that also is a process that also happened throughout the broader Chinese system, from government agencies to businesses as well. So one of the sentences you say is how MOFCOM brought huge delegations to Geneva because it wanted to show other agencies that the process was fair, and that if China is going to lose, it would have to make, and that when China was going to lose, it wanted these businesses to understand that the justification and how to bring rule of law and make compliance easier. So could you talk a little bit about how maybe some initial frustrations of China getting ruled against and people not really understanding what was going through the WTO appellate court's mind ended up eventually winning people over to the idea of WTO?
Right. What you mentioned, as we discussed in our article, the fact that MOFCOM's brought these big delegations that compose of not only the officials from MOFCOM, but also the officials from the other ministries that are involved in the drafting process for the legislation at issue, and even members of the firms. That is very important because when all these disputes were first brought against China in the WTO, the Chinese government didn't take it well because the Chinese government thought that if you sue me in the WTO, that is an act of hostility. So the Chinese government basically took a kind of hostile approach to this because they thought that if we are friends, you shouldn't start suing me in the WTO. But then gradually they realized that that is not necessarily the case. I mean, being involved in a litigation doesn't mean that you are at the end of the diplomatic relationship, because if you look at the other WTO members, US and EU, for example, they are among the best friends among all WTO members. But they are suing each other all the time. It's like more than half of the disputes involve, them suing each other, basically. So China started to understand this, and especially MOFCOM, they started to understand this because they are the ones who have to deal with WTO issues on a daily basis. But the people in the other ministries, they still lacked understanding. For example, people in the Ministry of, Ministry of Agriculture, Ministry of Telecommunication, Ministry of Industry, and the Ministry of Publications, and even this all-powerful NDRC. So they didn't understand. So what MOFCOM did was that, by taking them to Geneva, MOFCOM basically, in addition to litigate and defend China's interests, but also MOFCOM was, educating these other ministries, but telling them, look, this is how things work in the WTO. If you are saying that I didn't do anything wrong, it's not enough that you just say that. You have to prove that. You have to provide evidence that show them that you didn't violate text of WTO law. You have to show them, look, this is how I understand what a particular term or a particular word in the WTO agreement meant, and try to persuade the WTO panel at the petty body in agreeing with you. So they started to see this, and they started to see that the WTO litigation is not really a hostile act. Instead, it is a way for them to help themselves too, by help them to clarify, for example, what is the true rationale for enacting this legislation, and how this legislation could be better drafted so as to minimize its impact on trade, on international flow of trade. So that, I think, is probably the most valuable lesson, the takeaway from all these WTO litigations. And MOFCOM acted as basically a kind of anchor in China between the WTO and the other ministries, and helped to channel all these rule-abiding spirit to the other ministries in China.
So, as we move in our timeline to the mid and late 2000s, China starts to feel more confidence with this system and starts to bring more and more cases of its own. Can you talk about that evolution?
Yeah, that is something I observed, and I've written a couple of articles on that. If you look at basically the process of China's participation in WTO disputes, you can observe three distinct stages where initially, that is basically up until around 2006, China was very reluctant. So basically the first 5 years, China was reluctant to get involved in disputes. Whenever a dispute was brought against China, China basically says, yes, you are right, and then settle the case without getting involved in the full litigation, because China was afraid to litigate. But from 2006, China started to change its attitude and start to participate more actively by not only defending itself to the full length of the WTO litigation from consultation to panel to appellate body, but also bringing more cases against other countries. The turning point, I think, is because China realized around 2005-2006 that it is normal to have a WTO disputes, and it is normal to be sued. It is normal to sue other countries. That is why China adopted a different approach, because they realized that they couldn't just hide behind all this settlement all the time. They have to do something. So they started to be more active in the disputes, and that is what I would call a rule shaker stage, where they shake the WTO rules to try to gain some advantage. And then from 2008 onwards, you see that China entered a rule taker stage. That is the stage where China tried to adopt novel interpretations of key WTO disciplines or rules in a way that is more beneficial to its own interests. For example, you see this with regard to its interpretation on certain regulations governing subsidies, on certain rules governing the use of anti-dumping measures, and so on. So that is where you see China started to really use the rules to its own interests, and that is why I would call it a rule maker stage. So those are the three stages, and from the evolution of the three stages, you can really see that China was adapting. China's attitude towards WTO disputes was evolving. It was different than when it first acceded to the WTO. So that shows that China became more competent in using WTO rules. So that is another thing that we discuss in our paper, whereby you see that China started out as a kind of a student learning from the master like the U.S., but then as China gradually mastered the rules of the game, China started to use these rules to its own interests. So the student became the master in a way.
So what's interesting, comparing how China really has taken to the WTO and this realm of international legal dispute, is how for territorial issues and things like laws of the sea, China's still doesn't necessarily have. There's no love lost between China and other international dispute reconciliation systems. So could you explain the tension there, and why the difference in perspectives on these sorts of things?
Well, for territorial disputes, China is taking a different approach, as you mentioned, but that is related to the different perspective China is having on territorial versus economic disputes. Now, the Chinese government has in the past defined what it calls its core interests. If you look at the list of the core interests, one of the core interests would be national sovereignty and the territorial integrity of China. So that means that on these issues, because it relates to China's core interests, therefore there's no way for China to bargain, or to be subject itself to another international institution, be it a adjudicative body like the United Nations International Court of Justice, or another political body like the United Nations. So on these type of issues, China would not want to be subject to a third party. But on economic disputes, because economic disputes is not among the core interests, so China is able to take a more flexible approach by subjecting itself to the system, because China realized that, these are not core interests, and also deep down, if you look at China's interest in the long term, actually it is beneficial to China to uphold the rule-based international trading system like the WTO.
So it's important to think about the kind of broader context and the arc from going from Mao to this time where there are Chinese lawyers in suits arguing in front of appellate courts at the WTO. One of your interviewees said, "I am a person who lived in the time of the Cultural Revolution. I was in China from the worst time, and now I can say it's not easy progress for China to become what it is today. We went through a lot of ups and downs and suffered a lot. But now I see the people, news, criticism, comments, journalists. It's unbelievable. From your perspective, it might be normal, but for me, it's really unbelievable. Now we can criticize the government, comment on the policies, talk about the WTO. It's really changed a lot." So my two questions for you in regards to this interview is: do you recall when he made those comments, and what do you think it means for China as a country that on the one side is really engaging with this WTO international arbitration, but at the same time we have Xi Jinping consolidating power, apparently going to stay in cracking down on dissent, and apparently going to stay in the leadership indefinitely.
So this guy, his assessment has to be looked at in a longer time frame. He went through the Cultural Revolution, so he apparently saw the days that China was in much worse shape than it is today. So that is why he welcomed this more liberal approach towards freedom of expression, towards international rule of law, and so on. So I think if you look at it from that perspective, he is right. But as you said, if you compare the situation 5 years ago, or maybe a longer time frame from the 90s or the 80s to today, then you might be disappointed.
So another thing that was expressed in the end of your paper was this growing cynicism when it comes to WTO law, and how it's perceived as less important than it was maybe 5 or 10 years ago. Can you talk about the factors going into that and the potential implications that it has for Chinese policy?
Well, there is a host of reasons for this. On the one hand, you saw that in the WTO, the current negotiation round, the Doha round, went into basically problems for a long time, and then it became stalled about 10 years ago, since 2008. So a lot of people are saying that the WTO is dead. I don't agree that the WTO is dead. I think the WTO has slowed down, but it's definitely not dead yet. But that apparently, weakened the attraction of the WTO to some extent in China. And another reason is because there's a shifting of negotiations from the WTO to all these regional trade agreements, or free trade agreements, including the TPP and what China is doing itself, the RCEP, the Regional Comprehensive Economic Partnership Agreement. So that also reduced the importance of the WTO. And a third reason is because this increasing rise of protectionism worldwide, where you see, especially in the U.S. recently, with Trump came into the White House. So you saw that the U.S. has started to act more and more protectionist by using all these tools for trade protection, even though WTO has explicitly ruled that they are illegal. For example, Section 301, the WTO had a case before, and according to this decision of the WTO, it could not be used unilaterally by the U.S., but the U.S. still use it. So all of these factors combined together started to cast some doubt on the effectiveness of the WTO as an international institution. And I think that explains why there was this cynicism towards the WTO nowadays in China, and that combined with the increasing turn to more to the left by the Chinese government in a way by strengthening, for example, the role of the party, the role of the state-owned enterprises in the economy, can indeed give rise to some worries about how this is going to play out in China. And I think in the long run, I'm rating another shorter piece discussing what are the implications of the actions of the U.S. and EU on China. For example, about a year ago, when this provision on the non-market economy status of China that was contained in China's accession protocol expired, the U.S. and EU refused to grant market economy to China, even though according to the WTO agreement, it was very clear after this 15-year period that ended in December 2016, they could no longer treat China as a non-market economy, but they refused to do that. So I think this is going to backfire because China will learn these lessons, and China will learn the lesson from the US, EU that they could manipulate the WTO rules just for their short-term interests, and then China might emulate them, might learn from their examples and do the same. And if that happens, then that is bad news for everyone in the whole world.
Do you have any further thoughts on the implications of this recent the threats and tit for tat between the U.S. and China, throwing tariffs that certainly are not WTO compliant?
Yeah. I'm sorry that we have to end this with a rather unpleasant note, but this is the time we are in. I mean, if you look at the actions on both sides, of course, the U.S. have to bear probably a larger share of the blame because it's the U.S. which first started this. But on the other hand, if you look deeper into the U.S. complaint, you couldn't say that the U.S. did this for no reason, because part of the U.S. complaint is that when China joined the WTO, China agreed to move towards more of the market economy side of things. But if you look at what happened in the past 5 years, there has been a retract towards more like state-owned economy or the government-owned economy in China rather than market economy side. So I think the U.S. concern is legit in a way. On the other hand, if you look at the reactions from China, China retaliated with its own list of 50 billion items. And the Chinese government is saying that all these are WTO consistent, but I doubt this too. Just as the initial 50 billion list of the U.S. is inconsistent with the WTO rules, the new retaliation list by the Chinese government is also not consistent with the WTO rules either. It violated a host of WTO provisions just like the U.S. So if we continue doing this, everyone breaking the rules, then we will not have the best of the world for anyone. So I hope that somebody in both governments can come back to their senses and realize that this is not good for anyone, and stop this. And then maybe we could start to have more hope in the international rule of law.
Yeah, I think what's really important to emphasize what you hinted at is the importance of norms to this WTO system, and the kind of belief in the norms and the practice is what ends up leading to compliance. A WTO appellate proceeding takes a really long time. Countermeasures may not come into effect until years and years later. So it's really, the magic of the WTO is really the country's buy-in, right? And once you lose that, then a lot of the force that these ruling has starts to fade away.
Yes, I fully agree.
So on that note, I think we'll call it a day. Henry, thanks so much for taking the time. Hoping to have you back on the show sometime soon.
Sure, you are welcome, Jordan. Good luck on the show.